Welcome back, everyone. It is my privilege to introduce the moderator for Panel 2, Second Order Diversity, Professor Gerald Torres. Professor Torres is the Bryant Smith Chair in Law at the University of Texas School of Law. He is the former president of the Association of American Law Schools, a leading figure in critical race theory, and is also an expert in agricultural and environmental law. He came to the University of Texas School of Law in 1993 after teaching at the University of Minnesota Law School, where he also served as Associate Dean. Professor Torres has served as Deputy Assistant Attorney General for the Environment and Natural Resources Division of the U.S. Department of Justice in Washington, D.C., and as counsel to then U.S. Attorney General Janet Reno. His latest book, The Miner's Canary, Enlisting Race, Resisting Power, Transforming Democracy, with Harvard Law professor Lonnie Gunier, was described by Publishers Weekly as one of the most provocative and challenging books on race produced in years. Professor Torres is a member of the Council on Foreign Relations and the American Law Institute. He was honored with the 2004 Legal Service Award from the Mexican American Legal Defense and Educational Fund for his work to advance the legal rights of Latinos. Please welcome Professor Gerald Torres.
First of all, I wanted to thank Professor Piety for allowing me to kind of butt in. When I saw the symposium and I saw who was going to be on the symposium, I realized that I had actually been a colleague with virtually all of the symposiists. And I thought, well, it's a really important issue, and if I can contribute in any way, I'd be happy to. And so a place was made for me. We're going to do this panel a little bit differently. It is a panel on second order diversity. Although my dear friend and colleague and partner in exercise, Sandy Levinson, is going to deviate from the
illustrating second order.
It's going to illustrate second order diversity. Well put. It's going to illustrate second order diversity. By some people might think it's just being obstreperous and deviating from the task that he was assigned, but he's actually going to illustrate the idea. I'd like to begin by introducing Professor Tolson. And after she speaks, we're going to open it up for discussion, and we'll have discussion about her paper. And then we'll turn to Professor Levinson, and we'll have more discussion, I hope, that will finish out this session. Professor Tolson got her JD from the University of Chicago in 2005. She was on the law review there. Won the Mulroy Prize for Oral Advocacy in the Hidden Moot Court competition. She clerked at the Seventh Circuit for the Honorable Anne Claire Williams and the Honorable Ruben Castillo in the Northern District of Illinois. I should say one of my former students just joined the Northern District, John Lee. So it's obviously a very, very distinguished court. Now, she joined the the Florida State University College of Law in 2009, where you teach constitutional law, election law, employment discrimination, First Amendment, and she has published widely and has antagonized people like Sandy by defending partisan gerrymandering in favor of and promoting federalism. So I look forward to your talk.
First, let me say thank you, University of Tulsa, Professor Piety, and the Law Review for having me. Very daunting task, right? Heather Gerken, wow, okay. So I think I'm gonna channel my inner Schleicher, and talk about all the reasons Heather is amazing and wonderful. And then I'll say that, but there's this one thing, right? So Heather's theory of second order diversity emphasizes diversity of institutions, and she does so in order to create spaces in which minorities can dictate the outcome in a certain amount of cases. Now, this article, as well as some of her other pieces, Dissenting by Deciding, Federalism All the Way Down, tie into this larger theme about aggregating power in a way where decision-making is shared by both the majority and minorities. In many ways, her work is really path-breaking, in part because it gives us another way to think about institutional design, but also because it makes a strong case that statistical diversity should not be our primary focus, that there are other things that we have to consider as well in drawing institutions. So these pieces explore governance in its smallest components. It focuses on subunits in order to ask a very important question. What is the best way to allocate policymaking authority to electoral minorities so that they too can exercise meaningful power in our system? Relatedly, taking a micro-level view of governance also raises interesting questions about whether the power that electoral minorities retain within disaggregated institutions is sovereign or autonomous in any true sense, and more importantly, if it has to be. Although Heather pushes against hard federalism and the sovereignty that it requires, expressing dissent through the mechanisms of the state will still seem to mandate that dissenters have at least some sovereignty or plenary authority in order to distinguish dissenting by deciding from the conventional powerless dissent. Scholars have split on this question of how much sovereignty is needed in order to further the goals of federalism. But in advocating for variation among institutions that allow minorities to exercise power, perhaps we should not be so quick to get away from at least some variant of sovereignty that would make the power minorities exercise in these disaggregated institutions meaningful and enduring. Now, it may be a form of sovereignty that is weaker than the sovereignty typically promoted or touted by some federalism scholars and the Supreme Court in many cases, which sovereignty typically looks at whether a decision maker has final policy-making authority in some specific regulatory sphere. But it's still a type of autonomy or positive use of governmental authority that is not easily disturbed by the state in order to lend credibility and to put the power of the state behind decisions made by these particular groups. Now, I have to give a quick shout out to Ernie Young, the article he wrote discussing this issue of sovereignty versus autonomy. Yay, Ernie, thank you. But the reality is that it's difficult, if not impossible, to get away from some account of sovereignty in federalism theory altogether. So disaggregated institutions, in trying to understand this, are still a part of the state. So we generally view the state as sovereign, and so it would be odd in some respect to view this sovereignty as being lost when a state delegates some of its power to smaller units. It could be, and trying to understand this, is that the power takes a different form the further down the ladder we go, but it's still power in a meaningful way. All of this is not to say that notions of sovereignty can comfortably fit within the framework that Heather has outlined. In many ways, Heather's work highlights the tension that emerges when we try to translate our traditional understandings of power and authority into a context in which those factors take a backseat to other goals that can be realized at the sub-state level. Heather is undoubtedly correct that dissent often emerges de facto and in non-traditional spaces. She is also correct that rigid application of a fully theorized federalism model could constrain rather than promote the type of dissent that she cares about. Yet many of the examples that Heather relies on in her work are examples that show dissenters exercising the power of the state. So a jury that renders a verdict in a case, voters in a majority-minority district casting a vote for their preferred candidate, are all examples of formally bounded spaces that can promote the diversity of viewpoint with which Heather is concerned. And the reality is, unless these units can operate with some level of autonomy, the effectiveness of their dissent is significantly undermined. So from my view, the absence of sovereignty can lead to decisions by dissenters being overturned or disturbed by others too quickly or too summarily. If the decisions of dissenters are easily overturned or dismissed because they are outside of the mainstream, this would seem to undermine many of the normative benefits that second-order diversity provides, in particular the notion that it allows minorities to dictate the outcome in a mini-governance unit. I make this argument knowing that the absence of sovereignty or strong autonomy may not be problematic for Heather, who rebels against this notion in much of her work. Indeed, she focuses on the importance of voice and how disaggregated institutions allow minorities to exercise voice in the absence of formal autonomy. And in many ways, I agree with this. There's much to commend this approach. To use one of Heather's examples, the city officials in San Francisco undoubtedly pushed the national conversation forward when they decided to marry same-sex individuals contrary to state law. And in that situation, the decision was short-lived and overturned by a judge fairly quickly. But for other disaggregated institutions that make decisions that are less controversial but still outliers in many respects, for these institutions who are utilizing the authority of the state, circumventing their ability to express dissent by narrowing the scope of their authority can raise serious issues. Much like the decision of the San Francisco clerk's office to marry same-sex individuals, which was quickly put to a stop by a judge and triggered ballot initiatives against same-sex marriage nationwide, a school board that teaches creationism, or a jury that hands out a light sentence because it opposes the state's harsh sentencing regime, are also open to criticisms that they are expressing dissent in a way that is too far outside of the mainstream. But unlike the court that struck down the decision to issue same-sex marriage licenses, we don't necessarily have to conclude that these other outlier decisions are an abuse of authority, as opposed to simply being a valuable viewpoint and an interpretation of the law. In other words, we have to balance our ability to subject these decisions to meaningful oversight against our normative commitment to institutional diversity, which in my view means not depriving these subunits of all autonomy so as to render their decisions impotent and without the force of law. As Heather shows, outliers are good for democracy and good for pushing the conversation forward. But sometimes in order to achieve this, second-order diversity has to be about more than just voice. It also has to be, unavoidably and rightfully so, it has to be about power as well. Sorry, excuse me one second.
Oh, you're welcome.
My son gave me a cold 3 weeks ago and I'm still fighting it. Okay. So, in thinking about these concepts, Heather argues that there is a value, for example, to having a jury that is second-order diverse, that because of random assignment, there will be a significant number of juries in which minorities are sizable enough to dictate the outcome. According to Heather, the second-order diversity framework forces minorities to determine whether they want to influence jury verdicts in the aggregate across a lot of cases, or if they want to control the decisions in just a few set of cases. This analysis in many ways, well, no, not many, that's an exaggeration. In my one way, is incomplete because it does not adequately consider the extent to which the jury's discretion is constrained by the judge. Like many disaggregated institutions, the jury has evolved, but as it has become more representative, it has actually lost its authority in many ways. During colonial times, for example, trial judges were prohibited from exercising coercive power over the jury, so oftentimes they did not give instructions, and they had a limited ability to comment on the evidence or the credibility of witnesses. Also, evidentiary rules were more liberal, so a significant amount of information got to the jury in the past than will get to the jury today. The fact that the jury is more representative but less powerful today matters in making the cost-benefit analysis that the second-order diversity framework commands. To the extent that we care about jury verdicts in the aggregate and using outliers to influence verdicts overall, juries have a limited ability to independently express dissent because of constraints imposed by both judges and statutes. So perhaps what this means, in trying to incorporate this understanding of the importance of autonomy in this framework, is that as a part of our cost-benefit analysis, maybe we should tinker with the rules that govern juries in order to make them more autonomous and independent of the judge. For example, maybe this means employing a higher standard of proof before a judge can disturb a jury verdict. For example, manifest weight of the evidence instead of a preponderance in the civil context. Or maybe we now have another justification for statutes that prohibit jury nullification, which exists in almost every state. Or we may ultimately conclude that because the power of the jury has been significantly limited, and analyzing the trade-off between influence and control, it is better to have a few outlier verdicts because of the reality that the jury's limited power cannot really push jury verdicts in the aggregate too far in the direction of the policy preferences of the electoral minority. At the very least, such discussions illustrate the importance of jury autonomy to the second-order diversity framework. In addition to juries, Heather also does a great job of highlighting how considerations of second-order diversity can inform the debate surrounding the costs and benefits of choosing certain electoral forms over others. In particular, she highlights the fact that creating electoral districts and other governing units is more about electing representatives who influence legislative outcomes. It is also about electing representatives who can distribute goods and services back to their respective districts. Indeed, control over a district or governance unit can help minorities in a few ways, including agenda setting, using issues to frame the public debate, allowing legislators to wield power over goods and services even if they are not in the legislative majority. But in order to promote the values envisioned by Heather that emerge from promoting the diversity among institutions, particularly so that minorities can lead in some of these disaggregated forms, there has to be some level of autonomy in their decision making. For example, Heather refers to disaggregated institutions like city councils, school boards, special purpose agencies as mini governance units, a descriptor which indicates that focusing on the trade-off between influence and control at the level of these institutions in many ways is a false dichotomy, in part because the reality is that some control is still needed in order to have influence. Specifically, Heather points to the case of Priestley versus Etowah County Commission as evidence that having institutions that are second-order diverse can be valuable, particularly where political preferences find their strongest expression at the level of local institutions, like the board in Presley. There, individual board members made policy decisions and doled out patronage independent of each other. So even though it was a board, each member had significant authority over their constituencies. Yet, second-order diversity is an important consideration in this context precisely because of the power that individual board members had, power that was ultimately undermined and changed in anticipation of the appointment of an African-American board member, which arguably affects the ability of the board to be a mechanism that facilitates minority viewpoints. The facts of Priestley raise two very important questions. The first is, does our normative commitment to second-order diversity require that we acknowledge that the power of the board is now diminished, even if technically the board still remains an institution in which electoral minorities can express dissent? Or does our normative commitment to second-order diversity require us to make sure that the board is also an effective medium to express dissent, to the extent that we define dissent as dissent by deciding or dissenting with power? Along these lines, it matters that the Etowah County Commission altered its prior practice of allowing each commissioner full authority over resources delegated to that commissioner. To the extent that disaggregated institutions are a means of expressing dissent by power, perhaps it matters that the Supreme Court failed to see the full implication of the board's decision to take power away from individual commissioners. The loss of autonomy so as to facilitate racial discrimination circumscribed the ability of board members to further the goals of second-order diversity championed by Heather, and it deprived minorities of meaningful authority within these specific spheres. Thus, in assessing the trade-off between influence and control, the cost-benefit analysis has to include consideration of whether the control enjoyed by electoral minorities is actually meaningful within the institution. Okay, thank you.
What I'd like to do now is open it up to questions, and we'll take about 15 minutes for questions. Then we'll turn to Sandy. Okay, questions? Yes.
With respect to the effect on democracy of giving juries more power, what do you have to say with regards to that this would really lower consistency in sentences or with verdicts?
Well, I'm not going to say she did it first, but the general sentiment is that you're always going to have some jury decisions that are outside of the mainstream, and that this is good because, in essence, everyone is not going to agree on what an appropriate sentence should be. But the idea is that if you have a sentence that's too far outside of the mainstream, that there are still checks within the system that can control that, those specific outliers. But I think the point is that sometimes we have outliers. We should encourage outliers in order to maybe soften jury verdicts in the aggregate, Or, maybe the circumstances are such that in that particular case, the outlier is justified. But generally speaking, there are systemic checks that would prevent outlier decisions that are, for example, a manifest injustice or results in an outcome that's really distasteful.
I guess this is a similar question because I was interested in the picture that you drew, the historical picture of the jury's power, and I was wondering, like, compared to what period? Because if you look at the federal rules of evidence, they were supposed to be granting juries a lot more power, which Professor Swift at Berkeley has suggested is part of the reason why the judges have more power now because so much more evidence comes in rather than less. Like that the common law evidentiary rules actually restricted more than the current evidentiary rules about what the jury gets. Mm-hmm. So, but I was wondering whether you were saying that the way it's evolved, that judges now are excluding more often than they used to under the same set of rules, or is that what you were saying?
No, that's okay. So my point is that under the common law system, juries had significantly more authority than they have now. And in particular, the rules have evolved to where judges make more decisions now with regards to evidence, credibility of witnesses than existed under the common law system. Now,
so more authority, but less. They heard less, right? Because
they heard more under the old system than now.
Well, there were a lot more restrictions, right, on what kinds of who could testify and who was. There were competency tests for who was allowed to testify that don't exist. I mean, the federal rules of evidence were supposed to be a system of free proof, right? So that was to move away from that very restrictive kind of idea of only certain types of people can testify and only certain types of.
Well, that's true to a certain extent, but arguably under the federal rules now, it's much more judge-centered than jury-centered, which is kind of my point in terms of looking at the overall migration of our system from one in which the jury exercised significantly more authority. And of course, one thing that I've thought about that I'm not sure how this is the fact that we don't really have many trials anymore. You know what I mean? So, but I'm not exactly sure how that cuts in terms of like what I'm advocating here. But
yeah, no, I was just curious because I think maybe it's true. I don't have the empirical support for it, but I, just like. My intuition is that since 1974, maybe judges have become more proactive about excluding stuff and about overturning jury verdicts, and it's really not the rules changing so much as just their behavior under the existing. I mean, there's been rules changes too. But.
I mean, entirely possible. But generally speaking, and I can credit one of my colleagues for this insight, as the jury became more representative, the system definitely moved more in the direction of the judges. Now, I'm not saying that that's the only reason why it moved. I'm certainly not saying that, but I do believe it's one contributing factor.
Yeah, this is a broader question. In the 19th century, patronage political parties that were locally based took care of a lot of your problems. I mean, okay, there's problems with racism, et cetera, but think of the Chicago Machines or Philadelphia. They took care of all this stuff because they were, quote, voluntary organizations until we began to regulate and make parties a part of the state, which ruined their game and got rid of patronage. But don't we have a modern equivalent? That is, with the army of diversity regulators at every level of government and in universities and in corporations, isn't this kind of a patronage machine in itself, only it's got a little more legitimacy? Well, not maybe more than political parties, but it does have a kind of patronage aspect to it, both in hiring and in the groups that they favor. And it's very, very tied to general political partisan differences, we obviously know with voting. So why courts? What does the law have to do with this playing out of political forces that if you can't do it through parties, you can do it through endless regulation? But isn't this just a problem of interest, not rights, or proposed entitlements in a kind of political rhetoric, but certainly not a rule of law?
Well,
I mean, I'm not a lawyer, but I come in here and I say, what are law students doing with all of these weird political things that have nothing to do with sovereignty? They have to do with power, and they have to do with allocations of power through institutions that are set up formally and informally.
That's
The more
sovereignty versus
regulation you
autonomy,
get,
though. That's power.
The point is, the more regulation you get, the more you impose standards of rule of law, standards of equity, standards of fairness. And that's the death of political parties, isn't it? And it undermines the legitimacy of all of these patronage organizations called diversity commissions and equal opportunity, et cetera. Or, conversely, it just makes courts a part of an administrative regime that is partly patronage and interest-based. That is, it makes them part of an administrative political structure that they may have no proper business being in, except that.
But everything that I've talked about thus far is already governed by law. You know what I mean? So I'm not, like juries, the federal rules, statutes, electoral districts, the board and the commission in Presley was governed. I mean, the issue was whether or not they had to pre-clear any changes under Section 5 of the Voting Rights Act.
But colonial America, they used to draw a lot and have two lay judges sit by the real judge in Massachusetts and Connecticut. Come on, that isn't rule of law. That is rule of popular will. And so is juries. I mean, you draw them by law.
To the extent that our law is influenced by norms outside of the system, I totally agree with that. But there's still, law, to me, law still has something to say about how power is delegated to these institutions. Even when you have institutions, let's take your diversity example. They still have to act within the contours of the Equal Protection Clause in deciding how to allocate resources to the groups that they quote unquote favor. So to me, law still has something to say about how power is aggregated within our system, even when we're talking about these, subunits of the state or your diversity boards.
Yeah, I thought that, the rabbit in the hat, you spoke with regard to monitoring juries, that will give them a great deal of discretion except when they do something really outrageous. And so in that context, I thought of Stanley Fish's critique of what he calls boutique multiculturalism. That is to say, the toleration for cultural differences so long as they don't really offend us. So, all of us can think of examples, perhaps of different examples, but one might think of Congress's hostility to polygamy in Utah and conditioning the admission of Utah on, in effect, a change of doctrine by the Mormon Church and also how to write the Utah Constitution. Now, all of this requires a substantive theory of justice. So when a Texas jury sentences somebody to 300 years in prison, which I think they've done, or at least 100, it doesn't really matter whether it's 100 or 300 years, then, clearly most of my fellow Texans seem to think this is perfectly fine. I may find it outrageous, but what is in fact a judge supposed to do with regard to, say, litigation under the Eighth Amendment? If this isn't cruel and unusual, what is? Does that turn, into simply which of our intuitions triumph, which really does mean who has a majority on a court at any given time?
In reality, we're talking about a very small set of cases, right, where electoral minorities are exercising control of a jury. And so the question is, if we really do view the jury as a mechanism of dissent, we have to be able to tolerate some variation in sentencing to the extent that we care about the second order diversity that Professor Gerken promotes in her framework. Now, there will be some outrageous decisions, and I think she concedes as much. As Ernie pointed out, it's almost like she's trying to make people fight, right? But the reality is that it's a very small subset of cases, and from her view, the benefits outweigh the costs, right? Because you might get a 300-year verdict, but you might also get a situation where it's 100 years, which I'm sure still sounds unreasonable to you, Sandy, but to everybody else is like, okay, the person just got a life sentence, you know? So the line drawing problem will be a difficult one. How do we tell when a verdict is a situation where it's just completely outrageous and therefore the judge should step in versus when is it just somewhat outrageous, but we're going to allow this variation within our system? That I don't really have a good answer for. To me, that line drawing problem exists no matter what. But generally speaking, and if we view there being value to giving minorities control of the jury in just a small subset of cases, we may be willing to tolerate that.
Your earlier assertion was that as juries became more representative, that their role was constrained by the rules in the judiciary, and I'm not sure I disagree with that, but I observed that during the same period of time that juries were becoming more representative, so was the judiciary. So now I'm left puzzled, and perhaps you can enlighten me. Maybe you've thought this through, I have not. How is it that the juries are being more representative, but the judiciary that's being broadened in scope is not becoming more representative of the minorities at the same time? Because it seems like there are countervailing forces there, and yet there should not be. You grasp what I mean?
Sort of. Okay, so...
If the idea is to give minorities greater power.
Right.
And that's why we broadened out jury representation. But that's also why we broadened out judiciary representation of minorities.
The judiciary is
why
not
aren't they
representative
taking more
to me at
power
all.
as the judiciary?
I don't think the judiciary is representative at all.
There's another point too, right?
Okay.
Part is the decision-making structure, right? So if you turn to people like who've done, psychologists who've done studies on decision-making, right? The impact on as long as the judge is a single person, right? Even if the judiciary as a whole is more diverse, right? Is different and is going to have different impact on decision-making than if you have a jury that's more diverse, because the diversity of the jury itself will create a different decision-making dynamic. Sam Summers, I guess, is the fellow, I think he's done most of the work on that. Right? So in fact, they're really different kinds of questions.
And I would also say that the timing is different as well. The judiciary is certainly more diverse than it was, 15 years ago. But I would say that the jury, the diversification of the jury has occurred over a longer amount of time than the diversification to the extent that it exists in the judiciary. And so to me, it's two separate things.
Langbein, right, his work, right, indicates basically, as you pointed out, the civil trials, right, basically dwindled to nothing, right, and that the whole game's in discovery, right?
Right. Yeah.
Over here, right. We also know that because of the way the criminal operates, in fact, criminal trials are judgment on is far fewer than they were, right? So why wouldn't this argue for the increasing the latitude for jury nullification? Saying, since there's going to be fewer trials, right? Let's have a different. Let's take away all the restraints on lawmaking by the jury.
It might. It very well might. But to the extent we care about what Heather's trying to promote, then we wouldn't want that. Right? We wouldn't want more jury nullification because that takes power away from the jury. And the idea is that electoral minorities exercise power within this small sphere every once in a while. Right? So if we make it possible to nullify the jury in all outlier cases, for example, that's not really pushing the conversation forward.
No, I meant the reverse, actually, right? I mean, the cases that come to mind, right, are the Albion's Fatal Treaty, the book, right? England had the most bloody criminal code in Europe, right? Virtually everything was a capital offense, right? And when they went to trial, what you had is juries basically not finding the facts that would result in capital punishment, right? So that if you were caught on the king's land with snares or nets, right? That was a capital offense, right? Well, juries weren't going to condemn people for hunting, basically, right? And so you got the juries were basically not finding what the judge in Bushell's case, right, was the one where they imprisoned the jury until they came out with the right decision, right? And the British court said, you actually can't do that. The juries actually get to make a decision. which then led to restraints on what the juries could actually decide. And so since fewer cases are decided by juries, why don't we expand the range of what juries can actually decide, is my point.
Oh, I thought you said, why don't we have
Right.
more, yeah, I thought you said,
No,
why
no,
don't we
no.
have more juries?
Maybe that's not a question.
My response is, okay.
Ernie's already weighed in, it's not. Any other questions out there? All right, thank you.
Sure.